Welcome to the African Climate Alliance podcast, where we aim to answer the questions, what does climate justice look like in Africa, and what will it take to achieve it? In this second season of the podcast, we are talking all things cancel call. Over the course of the 5 episodes, we will dive into the multifaceted impacts of coal mining and the way forward for our energy future. From frontline advocates in coal-affected communities and legal experts discussing the environmental crisis to the transformative power of spiritual leaders, each episode delves into the diverse experiences and perspectives, encouraging us to engage with the urgent need to cancel coal for a just and sustainable future. The conversations on this season are hosted by Sarah Farista and Otila Nkarimen, 2 intersectional environmental activists and members of our Cancel Call Youth Task Force, who both embody what it means to speak truth to power and call for justice and change. The task force is a small group of dynamic young activists across South Africa who are campaigning to stop the new coal-fired power. Today, we are in conversation with Lebohang Dube from the Center for Child Law at the University of Pretoria, who will share more about the rights of the child and the deadly air case. We will hear their visions for a sustainable and equitable future and discuss the importance of centering youth voices in the just energy transition. Let us dive in.
Welcome to the African Climate Alliance podcast. I'm Sarah, and today we are delighted to be in conversation with Lebohang Dube as we talk all about the perspective and experiences of children and youth who are at the forefront of the environmental justice movement and the importance of centering youth voices in the just transition. For those of you who aren't familiar with Lebohang, Lebo is a candidate attorney at the Center for Child Law. He holds an LLB from the University of the Free State and is currently doing his LLM in environmental law at the University of Pretoria. His background includes student activism as a former student for law and social justice leader and a Young African Leaders Initiative Fellow. He has professional and grassroots experience, including community organizing and education in sexual and reproductive health rights, mining-affected communities, and child rights. Welcome, Lebo.
Thank you very much. I appreciate the time and thank you.
Likewise. So after that very impressive introduction, I am going to move into the first question. Could you explain in simple terms what the deadly air case is about and why it's significant?
Thank you very much. So the deadly air case is an important case in the South African story of democracy, but also the South African story of addressing not just past injustices, but continuing injustices that reflect the economic divide between the haves and the have-nots in South Africa. So basically, the case concerns the dangerous levels of air pollution in the Highveld area. So a bit of background. In 2007, the Minister of Environmental Affairs declared the Highveld priority area. So that is the area in the east side of Gauteng and the western side of Mpumalanga, where primarily a lot of coal production and electricity generation takes place. And for that reason, you find that the air pollution is at dangerously high levels. And as part of the National NAMACA, which is the National Environmental Management Act, Air Quality Act, the Minister of Environmental Affairs is clothed with the authority to declare such areas as a priority area so that the government and other stakeholders can focus on the area to firstly reduce air pollution and to find strategies for communities in the area not to cope with the air pollution, but also for a long-term reduction of air pollution in the area. So while this area was declared such a high priority area in 2007, since then, not much progress has happened. So you find that the air pollution has increased, the health effects and social effects, socioeconomic effects on the people who stay there have been exacerbated over the years. So communities in the area and other advocacy groups, including Trustees for the Time Being for Groundwork, which is an organization that organizes and advocates for environmental justice in South Africa, took the minister to court to ask the minister to take steps to reduce the air pollution based on the legislative framework that are in place to ensure that that is done. So this case has been going on for several years. However, last year, not last year, in 2022, the case made it to the Pretoria High Court, and the minister, including her advisor, were before the court, and they had to answer with regard to the implementation plan. So when an area is declared a priority area, there's an implementation plan that is in place, and there are regulations that will regulate how that implementation plan is supposed to be administered. But the problem in this particular case is that there are no regulations. So that's the primary cause for this particular case, where there aren't any regulations, and the activists and advocacy groups in the area took the minister to court to ask that the court declares that the dangerously high levels of air pollution, firstly, are an infringement of the residents' right to an environment that is healthy, that is not harmful to the health and well-being of those residents, but also particularly to ask the court to compel the minister to promulgate those regulations so that the work on the ground, but also administratively, can start to ensure that that air pollution is reduced. So yeah, in a nutshell, it's about the dangerously high air pollution in the high-fall priority area. I hope that
Thank
makes
you.
sense.
No, it 100% makes sense. And I think the background and everything you shared has been super interesting and helpful to our listeners who haven't heard about the Deadly Air case. I remember following it specifically through the Center for Environmental Rights. And I remember reading an article that was published in March 2023 about when the case was launched in June of 2019, and VEM, the environmental justice groups involved. And like you mentioned, that Section 24 of the Constitution states that everyone has the right to an environment which is not harmful to their health or well-being. And we're clearly seeing that that right is not afforded to those who are in those high-felt areas. So that brings me to my next question is, how does the South African Constitution protect people's right to a healthy environment? And how does this relate to the Deadly Air case?
Awesome. Thanks, Sarah. So we've already alluded to the Constitution. So Section 24, as you've already stated, the first part states that everyone has a right to an environment that is not harmful to their health and well-being. And then it goes on to the second part, which is paragraph B, which states that everyone has a right to have the environment protected for the benefit of the present and future generations. And it further mandates the state to take reasonable steps, whether it be by promulgating laws or other measures to ensure that pollution is prevented, ecological degradation is prevented, and also the state is supposed to promote conservation. And so in terms of the Constitution, it's quite clear that the right to a healthy environment, or one that is not harmful to one's health or well-being, has a similar status as other socioeconomic rights, such as the right to life, the right to health, the right to access to education. And so often when we think about environmental rights, we think of them in isolation, and we aren't able to pinpoint how it's violated. However, this case helps us to make that connection. So from Section 24, as a start, in the case, the applicant also made link to, for example, the right to education. Because if you have unhealthy levels of air pollution in the area, it means that people who live there are most likely going to be sick, meaning that they might have a poorer quality of life. Students and learners won't be able to concentrate in school as compared to those students who are much healthier. They'll be susceptible to long-term health risks, and also they won't be able to access other rights, such as the right to, as I said, to access education, the right to high quality of life, and other socioeconomic rights. And so what Deadly Aid does is that it's put for not only Section 24, but also the other interlinked rights, including, for example, the right of children's rights, because as Section 24 clearly states that it applies not only to the present generation, so not only to children who are born and are here now, but also to children who are still to be born. And it also takes into account those people who are children today who will be adults tomorrow, because they will inherit the area as adults. So the importance of this case is exactly that it highlights that Section 24 right, but without neglecting the link between that right and other quote unquote everyday rights.
Absolutely. I like what you said about the effects of environmental degradation and how it's not a surface level. The rights that are being infringed upon are not in isolation. It's a layered issue. We need to look at this
Sure.
from an intersectional lens because, like you said, it's not just affecting people's health. And by the way, physical and mental health, it's also affecting
Sure.
their education and future generations.
Yeah.
So what we're seeing is environmental degradation it's deeply intertwined with various aspects of our society, and social injustices and climate injustices are heavily interlinked. And what I wanted to ask was, what were you already mentioned it previously about the key arguments made by the environmental justice organizations in the Deadly A case and what was brought up in court. But what was the government's response to the allegations of failing to address air pollution in the Mpumalanga Highveld area? Is there are they taking accountability? Are they putting measures in place? Because as you said, this has been going on for longer than, I think you mentioned since 2007.
Yeah, since it was declared a priority area. So, so for 19 years, that was the most significant action from the state in respect to this area.
So today, in 2024, we can see that this is still a prevailing issue. It has not gone away. What was the government's response to the allegations of failing to address air pollution in the Mpumalanga Highveld area, and what is their current response? Because it's a present day issue. Yes.
Sure. Okay, cool. Thank you for that. So I'll answer that by firstly going back to what the the specific request by the applicants in this case. So the first thing they asked, which we've already discussed, is that the air pollution in that area is a breach of Section 24, particularly Section 24A. So Section 24A is, as we've mentioned, is a clear right, the right to an environment that is not harmful to one's health and well-being. So firstly, the applicants wanted the court to declare that the state has indeed violated that right. And secondly, the applicants were asking the court to compel the minister to implement the plan. So after the declaration of the Highveld priority area, there's a plan that goes with it, but it's obviously hasn't been implemented thus far. So the applicant asked for that. And then lastly, a declaration that the minister is not just a bystander, that they have a statutory obligation. So meaning that they have a duty. They have to, it's not a choice, it's not discretion, but they have to take certain steps, such as promulgating or prescribing regulations which is basically a type of law that regulates the existing law, which states that the area is a priority area. I hope that makes sense. So basically, the minister then had to respond to those allegations. So the first thing they said was, there's no such obligation. So the applicants were saying there's an obligation, you have to, it's not a discretion, it's not an ask, it's a must. But the minister is saying, well, I have a discretion, I can decide whether to prescribe regulation to ensure that that plan is implemented. So that's their first argument. The second one is that we can't argue directly from the Constitution, which is quite strange, right? So they're arguing
Why is
that
the Constitution there then?
exactly. So it's a technical legal gap, if I may put it that way. Basically, meaning loophole. There we go. Thank you very much. So basically, it's where they are arguing that that is a right in terms of the Constitution. However, there are laws promulgated by Parliament to materialize that right. So they are arguing that let us rely plainly on those laws, that legislation by Parliament, because the right in itself is prescriptive. It's mainly to guide. That's their argument. And therefore, we need to rely, in this particular case, based on Section 24, there was then a framework legislation that was passed by Parliament, the NEMA, which is the National Environmental Management Act. And under it, there are specific acts that deal with several aspects of the environment. And in terms of air pollution, there's one called the Air Quality Act. So in terms of the Air Quality Act, the minister then has to do the promulgation of the regulations and declare areas high priority area and all of that. So the minister is basically saying that her duty is limited to that legislation, which really doesn't make sense, right? And then they plainly say that Section 24 was not violated in this case. And then lastly, that since the declaration, there hasn't been an omission or an action on the side of the minister that would warrant the courts to intervene. So basically, they are saying their hands are clean, they have nothing to answer for, which is quite ridiculous and actually an insult to the many poor, majority Black people who live in the area of health and social impacts of the air pollution. So that was the response from the state. Quite disappointing.
I want to say disappointing, but not surprising. I mean,
absolutely.
We constantly seeing our politicians constantly playing dodgeball with holding themselves accountable.
Absolutely, yeah. I think accountability is one thing that the state really tries to dodge as much until they are forced, and it's unfortunate because such cases are expensive. They're inaccessible for a majority of people. So in this particular case, it's great that we have a lot of activists and lawyers that are involved, although it has taken quite a while.
So that's what I wanted to ask next. If we have the Constitution and we have the lawyers pointing out the rights that are being infringed upon, and we have the evidence for these rights being infringed upon, and the government and state are refusing to hold themselves accountable, despite court ruling that they are responsible for this, where do we go from there? How does this impact future efforts to address air pollution and protect public health in South Africa? Because a lot of what we see, especially now with the cancel court case that's currently taking place with our favorite ministers, Barbara Creasy and Wede Mantashe.
Mantashe, yes, you got it.
They simply do not care. There's so much apathy. There is so much shady, underground, illegal mine deals going under the table that the public aren't all blind to. We can see what they're doing, and we can see the effects. And you spoke about this court case. You spoke about the outcomes of Pretoria's High Court's decision regarding the deadly air case, and you've highlighted why it's important, but you've also mentioned that state isn't holding themselves accountable, specifically within the Mpumalanga High Veld area. So how does this decision impact future efforts to address air pollution and protect public health in South Africa, going back to the outcome of the Pretoria High Court's decision with the deadly air case?
Yeah, so just to comment on your statement, it definitely is an insult to South Africa in general, because the idea of the state and having a dedicated office or person to address certain social concerns, such as in this case the environment, is so that we can hold them accountable and we can interact with them. And participatory democracy is about that. It's about being able to interact with the state smoothly, but also to hold them to account. And this is one of several classic cases where that's not the case. And unfortunately, that has become the South African story. But on the other hand, what as South Africans, as a response, what we've over time started to find ways around the traditional bureaucratic ways of interacting with the state and holding them accountable. For example, outside courts and outside the parliamentary process, we organize. For example, we have the African Climate Alliance. We have individual lawyers and activists who have advocacy programs and mobilize people on the ground around a certain advocacy issue, in this case being the High Veld area. So on the other hand, it has energized those efforts. More and more individuals and more organizations are coming together to respond. And the importance of this case or similar cases is that it energizes those efforts. It energizes the mobilization on the ground. It energizes individuals' sense of participation, because sometimes, not even sometimes, I definitely know the state benefits when we are inactive. Their inactivity in implementing these laws or in just ensuring that our rights are upheld, then the impact on future efforts for us is exactly that. That firstly, we've learned lessons through this process, the legal process, but also we are energized, but also it sets legal precedent. So in the judgment, the court found that firstly, that the poor equality in the area was a breach, as we've discussed. But then they also found that this right is unqualified, meaning that there's no what if, there's no excuse of time, there's no excuse of resources. The state is obliged to act immediately. It's an immediate right. So it's similar to the right to education, which the court also looked into and said that the right to education is an immediate right. You can't say we are taking steps over time to ensure that South Africans can have access to education. This right has been interpreted by the state to be one that is immediately realizable, meaning here and now. That's the term that they use, here and now. And also, the state has the duty to take the steps to make it possible for that immediate realization. Meaning that upon the minister leaving that court in 2022, she had to take steps immediately. I don't know in terms of people who live in the area if they see any impact of any steps that might have been taken at the time, but I don't think so. And then lastly, the second part of Section 24 is the one that is a wider right, to the extent that the Constitution does say that the state needs to take steps to realize that right over time. However, the court then, in this particular case, came back and said that, wait, Section 24B is an extension of Section 24A. So you cannot isolate the two, meaning that the rights of the present and future generation living in the area also need to be immediately realized. So that gives us ammunition as activists. It sets precedent, and by precedent, I mean that in future, for example, in the cancel call case, the applicant can argue that this court found that Section 24A is an immediately realizable right, and that such a violation or inactivity on the parts of the state is a violation that breaches that right. So it offers us both legal ammunition, but also mobilization ammunition on the ground.
No, 100%. Thank you for that response. There's a few things that I want to touch on that you brought up. The first thing firstly, I love how the state is like, okay, we're going to find loopholes around this, and they don't think we can find loopholes within their loopholes to hold them accountable. So big shout out to the lawyers who are currently fighting for environmental justice. And the second thing was what you brought up about education and how education is a right, and that's a right that's taken quite seriously in South Africa. And we're constantly talking about decolonizing our education system. And I want to focus it more on an ecocentric lens. So in terms of climate literacy, South Africa has the lowest climate literacy in well, not in the world, but one of the lowest climate literacy rates. And I think what's so important about climate literacy is and people in these areas, such as the Mpumalanga Highveld area, they need access to good education, and within that education, climate literacy, because they are facing the effects of pollution. It's a lived reality for them.
Yeah.
But they are also the people who could be the ones holding the solutions that are gonna carry them out of these situations, because clearly the state isn't interested enough in providing solutions for them. And environmental justice organizations, we can help and represent them as much as we can, but we also don't want to create a savior complex and empower those in those communities to have spaces where they can bring up their innovations and solutions, start addressing this issue at a grassroots level, because going through parliament and court, it's shown to be our leaders are very disconnected from the lived reality in these areas. So I wanted to then ask, and you brought it up. Well, you answered the two next questions in your previous response, but what role does the law play in? So you mentioned the role the law plays in holding governments accountable for environmental injustices, and we've seen how even when the law is there holding governments accountable, they refuse to accept that accountability and be proactive in providing solutions. So how can ordinary citizens, particularly youth and children, get involved in advocating for change? You've mentioned activism, but just a message to the listeners on how they can get involved.
I just want to quickly touch on the climate literacy aspect. South Africa is a signatory to the Convention on the Rights of the Child, which is basically, it's an international law instrument that regulates children's rights. So it's the international constitution of children's rights, so to say. And in the convention, it's clearly stated that the state parties, which South Africa is, also have a duty to, within their education programs and curriculum, to include environmental literacy as part of the curriculum. So that part is already there. As far as implementation, I'm not too sure to what extent the education department, which is another minister now, so we have 3 ministers that are complicit to this, also has a duty to ensure that learners, upon finishing matric, not just aware, but also appreciate environmental issues, or are aware of, or are equipped to be able to respond adequately to environmental issues, including climate change. So that's just the one part. I think we've already touched on, for example, mobilization and organizing. One thing that we've seen past few years is exactly that: young people and children, either at an individual level, the community level, or at a national level, organizing, coming together, discussing issues within their immediate communities and how they are affected. So with that, without the state, we've already started to get the ball running, and particularly the African Climate Alliance has done a great job in that part. But also, I think sometimes when activists and lawyers and other advocates push for these issues, court or at a national platform, we sometimes are oblivious of the intersection. And you find that for ordinary citizens, they might not care much about the equality, but they do care about their health. They might not care much about, or at least might not be reactive much to equality or to climate change, but they will definitely react to the effect as far as it affects their daily lives. So one way to interact with different communities using different tools and also understanding their immediate concern. And you then find that issues of climate change, environmental degradation, and related issues then come afore, as we had already discussed, that is an intersectional, interlinked issue. So that's one way of, on our side as activists and advocates, to interact with our community, but also such cases and advocacy that is being done does speak to community. And here's an example. You have the mining affected community who already have organized, who you might find that when you interact with them, they might find issues of access to health, access to education, service delivery as more immediate as compared to climate change. But then upon further discussion and interaction, you find that climate change is a cause, or at least is an important factor in their immediate concerns. So to get more people involved in climate action means us addressing those intersecting issues and struggles, and also being able to be genuine about how they relate to quote unquote the bigger issue of climate change.
We're existing in a system that's actively working against us. Well, that's if you're not a rich white man. But
It's Christian.
Yes, the system is. It's not that the system is not working. The system is working exactly how it was intended. Sure. The capitalist system was meant to function this way, and to produce a reality in which people are unequal, and the wealthiest are the minority, and those who face the effects of things like climate degradation are the majority, and poorer Black communities. This is why the system was set up. It was intended to run this way. So when we seeing that the system isn't working or working as it's intended to, but not serving us, it can feel daunting to start alone. But there's so many communities, there's so many groups.
Sure.
Just to name some off the top of my head, there's the African Climate Alliance, there's Fridays for Future Gauteng, there's Extinction Rebellion, there's always someone out there who needs help and support.
Yeah.
Because the state is not providing for them.
Absolutely. I think I definitely concur with you that the system is working as it was designed to, and it has morphed and improved. We have the latest updates of ruthless capitalism today, and we're experiencing it. And it reminds me of a quote I once saw the internet where a trade unionist from Brazil said that environmentalism without class struggle or without responding to capitalism is gardening. So, so sometimes we want to look at environmentalism just as, just about, greening the world, planting the trees, which is important, but there are deeper and more consequential questions around the climate, the climate emergency in South Africa. For example, last year, the repertoire, who's basically a chief researcher um, in the United Nations, so the repertoire for the environment, came to South Africa to just observe. And he found that spatial apartheid and environmental racism is still alive and kicking in South Africa, where he particularly noted the communities living around landfill sites because they have no choice. They reclaim some garbage, they recycle, and that's their livelihood. But those areas were designed that way. Landfill sites are in certain areas for a reason. Coal plant and, and, and electricity generation plants are in certain areas with certain people living there for a reason. It's part of that grand design. Call it capitalism, apartheid, imperialism. Uh, it's part of the plan, and unfortunately, a lot of people are reluctant to discuss that, to discuss the bigger problem, the elephant in the room. Uh, Poor elephant. Why should I say elephant? But anyway, yeah. But yeah. So I'm just commenting on what you're saying. That the bigger issue is a systemic one, and as much as litigation does take us a certain step in terms of mobilization and getting some immediate relief, the bigger problem is a bigger problem. So to say.
No, exactly. And I think also placing the activist in the context of
Sure.
the country. I mean, for a long time, people labeled, well, even currently, people label climate change as a very white person's issue.
Yeah.
Hug trees, walk barefoot outside, connect with the
Yeah.
environment. But it's so much more and deeper and intersectional than that.
Yeah.
It's looking at humans in the environment and how they are having an effect and also facing the brunt effects of climate change.
Yeah.
And with the talk of apartheid, and you were mentioning that quote by I think it was a trade union that you said. It reminds me of the well.
It's by a Brazilian trade unionist in colleges named Chico Mendes.
Chico Mendes.
Yeah.
That reminded me of Solomon Mahlangu. Well, there's a building at the university I attend. It's called Solomon Mahlangu, and a lot of people just like let the name fly over their head as just the name of a building. But for those viewers who don't know, Solomon Mahlangu was a South African anti-apartheid activist, and he became a symbol against the apartheid regime. But before his execution in 1979, he famously said the words, "My blood will nourish the tree that will bear the fruits of freedom. Tell my people that I love them. They must continue the fight." And this quote reflects not only his commitment to the struggle for justice and equality, and even though Mahlangu was primarily known for his activism against apartheid, his words also resonate with the environmental justice movement, symbolizing the sacrifice necessary for the betterment of future generations and the interconnectedness of various struggles for liberation.
That's profound, because what I take from that also is firstly the fact that he was young. So it's for that reason that even during Christmas 4, it was the Solomonic Call that symbolized student mobilization at the time. But also that particular quote also denotes the relationship between the environment and indigenous indigenous systems and spiritual belief systems, practices, and knowledge, to the extent that for many communities in South Africa that still adhere to traditional practices and beliefs, they have a particular relationship with the environment, which, when compared to a more Western lens or perspective of the environment, is quite interesting in that, for example, when Solon Mahlangu talks about his blood hitting the ground, that's a powerful analogy of the relationship that the land as well as the environment, uh, 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 the relation between the land and environment and African people in general. And so you find that in responding to the climate crisis or general environmental degradation, it's important to also take note of indigenous knowledge systems that have existed for thousands of years, that have gone through climate catastrophes and climate and natural disasters, and that have adapted to be able to respond effectively. An example, there's a case, a Gongose case, where a member of a community, a traditional community, was fishing, and they were arrested because that's a protected area in terms of the law. Yet, in terms of his customary practices, there are rules as to when you fish, how you fish, and which fish you go for at a certain time of the year. And so that was his argument, to say that, well, you're coming to me with legislation, laws, telling that I can't fish. Yet, firstly, I'm not responsible for the environmental issue that brought us to a point where certain area is protected. However, my practices and my beliefs and my knowledge forms part of the environmental response to climate change and climate degradation. So I'm just noting that it's also important to note that different approaches, Afrocentric approaches, are available and require not just recognition, but require implementation and empowerment to respond to the climate crisis.
Thank you so much for that, Lebo. Also, just to add, if listeners are interested in looking at the just transition away from fossil fuels towards a renewable energy in a South African context, take a look at the Climate Justice Charter. It is available in all of the South African national languages. You simply just type up the Climate Justice Charter on Google and it will come up, and is a great tool to broaden your understanding of climate literacy in a South African context, and it covers all intersections of the climate injustices that we face. Okay,
one more addition, sorry. Before we go, I'll beat myself if I don't share that. So also for listeners, particularly young listeners, children, to go look for the general comment number 26 from the United Nations Convention of the Rights of the Child. It sets out generally what all young people and children around the world want to say and how they feel and how they are responding to climate change. And it also gives recommendations on what your local leaders are supposed to do to assist in, on one hand, adaptation, but also on advocacy, on the advocacy aspect and empowerment aspect. So it is available on the Center for Child Law website. You'll find the general comment number 26. There we go.
Brilliant. I will even be taking a look at that. I didn't know that was...
Please do. And there's a child-friendly version as well. So,
okay.
So a lot of effort has gone to to interact more with children, in particular, people under the age of 18, because as the Constitution also says that both the present and future generations have that right, whether they are born or not.
No, that is fantastic. Okay. Thank you so much, Lebo, for being here today. And all the best with your advocacy work going forward. We should definitely keep in touch and connect. And thank you so much and all the best going forward.
Thank you very much, Sarah. Thank to you and the African Climate Alliance for inviting me and for the conversation. And I look forward to further engagement, and definitely you'll get invitations from us, both you, the African Climate Alliance, and the listeners should be on the lookout for some events around environmental justice from the Center for Child Law. Check our social media.
It was my greatest pleasure and my honor. Thank you.
Awesome. Thank you very much, Sarah.
And that wraps up this episode of the African Climate Alliance podcast. If you found this episode meaningful, please share it far and wide. You can stay connected with us by following us on our social media platforms, Instagram, Facebook, and Twitter. This season supports the Cancel Call court case. The court case is the first time in South African history that youth have led on a climate change court case against the government, challenging their plans to introduce the 1,500 megawatt of new coal-fired power electricity. For more information on the Cancel Call campaign and the court case and how you can get involved, visit www.africanclimatealliance.org/cancel-call. All links will be left in the episode description. Catch you on the next episode.